I'd like to introduce Chief Judy and Russ Diabo. Chief Wilson has served her community for 10 years as chief and 8 years as a council member. She is a strong advocate for recognition of inherent title and rights and self-determination and for fundamental shifting needs for the survival of all peoples. Her education includes public administration with a focus on governance, public relations, and media, and she has experience as a data technician, communications officer, project developer, news reporter, broadcast manager, and market coordinator. Chief Wilson is currently a member of numerous boards and committees, including the Union of BC Indian Chiefs Executive as Secretary-Treasurer, and the BC Specific Claims Working Group as a co-chair. Her co-presenter this morning is Russell Diabo. He is a policy advisor to the Algonquin Nation Secretariat, a tribal council, and senior policy advisor to the Algonquin Wolf Lake First Nation. He is also an editor and publisher of an online newsletter for First Nations political and legal issues, the First Nations Strategic Bulletin. Mr. Diabo is a member of the Mohawk Nation at Ganawage, Quebec.
First of all, we want to recognize that we are on Mi'kmaq territory in Mi'kmaq Nation. I want to thank them for hosting us here. And I want to go through this rather quickly. We were asked to talk about the impacts of Canada's rights recognition framework on land tenure policies and processes. And I found it interesting that hardly anybody, well, I don't think anybody's really mentioned it in the last 2 days of panels, but it has, I think, serious consequences. The parts of the presentation is we have a chronology of land claims policies, key Liberal platform promises, the Trudeau government actions, and the recognition framework itself, which actually is from an overview document that became publicly available September 10th. And this is a summary of that document and then our conclusion. But also Chief Wilson will add to that. So in 1971, the Supreme Court split on whether Aboriginal title existed or not in the Collar case. They lost on a technicality. I didn't put on there, but in 1969, there was the white paper on Indian policy to terminate rights. So the Trudeau government was pretty shocked. Trudeau the elder, the dad, was pretty shocked when the Supreme Court handed down a decision that Aboriginal title may still exist in Canada because they were split. And that prompted them to announce their land claims policies in 1973. Prime Minister Pierre Trudeau and Minister of Indian Affairs Jean Chrétien. And so they identified comprehensive claims and specific claims as the two main types of claims that they were going to negotiate. Of course, comprehensive claims were parts of Canada where there weren't land treaties dealing with Aboriginal title, and specific claims, as we know very well here, deal with the lawful obligations of the Crown around treaties, Indian lands, and Indian monies. And in fact, there was a third type of claims arising out of the Royal Proclamation, but they kind of dropped that after. So these are the two main types of claims they continued with. And the first comprehensive claim settlement, of course, was the James Bay Northern Quebec Agreement. First with the James Bay Agreement, and then they added on the Neskonlith and the Northern Quebec Agreement. So that was between 1975 and 78. While the James Bay hydroelectric dam was being constructed, they were negotiating at the table on that settlement. In 1981, the specific claims policy was revised in outstanding business. That's also when the comprehensive claims policy was revised in all fairness policy, and that was reaffirmed in 1986 as the comprehensive land claims policy. They wanted to make sure it was clear that the word land was put in there because it was separate from self-government. Because at that time they had a community-based self-government policy, and you had to negotiate those issues separately, self-government and land claims. Of course, in 1996, the Royal Commission on Aboriginal Peoples released its report with recommendations, which made major recommendations around the whole relationship between Aboriginal peoples and the Crown, and a lot of those recommendations dealt with the claims issues and treaties and land. And in 1997, of course, the Dartmouth decision came down for the first time saying that Aboriginal title exists in Canada, and they laid out a test, some principles and a test and put the matter back to, to the court for a future case. 2007, of course, we know the Justice at Last report agreement with AFN was reached on the specific claims process during the Harper government period. Then in 2008, of course, part of that agreement was to set up the specific claims tribunal through legislation, which took place in 2008. 2014, the Chilcotin decision on Aboriginal title was handed down, which basically reaffirmed a lot of the principles in Delgamuuk, but it also stated that although they were granting Aboriginal title to a portion of the Chilcotin lands, they also said the radical or underlying title belongs to the Crown. So it's basically still relying on the doctrine of discovery in the Supreme Court. 2014, the Harper government also issued an interim policy called Renewing the Comprehensive Claims Policy time, well, just before the Douglas Eford report, who did a report on the Comprehensive Claims Policy as well. He was retained in 2014. 2016, the Auditor General issued a report on specific claims outlining issues with problems with processing specific claims. You're all familiar with that here. I don't have to go into that. And this year, the Standing Committee on Indigenous Affairs did a report on Indigenous land rights. So they heard testimony on comprehensive claims, specific claims, and self-government policies, and they issued this report. And if you haven't looked at it yet, the government did issue a response, I think on September 17th, responding to the recommendations of the Standing Committee. You should have a look at it because there is a number of recommendations that deal with specific claims as well as comprehensive claims in those recommendations. Now, in 2015, when the Liberal government was campaigning, they made a number of promises on Indigenous issues during the election. They promised to immediately engage in a renewed nation-to-nation process with Indigenous peoples. They prioritized developing a full partnership with First Nations, a federal reconciliation framework. So they said they were going to do this. The framework will include mechanisms to advance and strengthen self-government, address outstanding land claims, and resolve grievances with both existing historical treaties and modern land claims agreements. They also said they'd enact the 94 recommendations of the Truth and Reconciliation Commission, including adoption of the United Nations Declaration on the Rights of Indigenous Peoples. They promised they'd recognize and respect Aboriginal title and rights with the caveat in accordance with Canada's constitutional obligations, and further those enshrined in the UN Declaration on the Rights of Indigenous Peoples, which is basically Articles 26, 27, 28, which the Trudeau government hasn't mentioned at all since they formed the government. And that's seeking restoration of lands, territories, and resources that Indigenous peoples traditionally held. It's Article 26. Article 27 talks about jointly setting up a process to adjudicate those land rights. And 28 talks about restitution for lands that aren't restored, lands, territories, and resources. And of course, those articles would definitely deal with specific and comprehensive claims policy, but they haven't talked about those articles applying, how the Trudeau government's going to deal with them. The Liberal Party of Canada also endorsed the recommendations of the Eford report that I mentioned, Douglas Eford, which did a report on the comprehensive claims policy. This is a big one. They promised to undertake a full review of regulatory law, policies, and operational practices in full partnership and consultation with First Nations to ensure the Crown is fully executing its consultation, accommodation, and consent obligations. This is their word, including on resource development and energy infrastructure project reviews and assessments. You see how that's gone. In accordance with our constitutional and international human rights obligations. And this review now has been rolled in as of the last cabinet shuffle. They have a committee on reconciliation in the cabinet headed up by Jim Carr, who's the Minister of, I think, International Diversification or something like that. I read pipelines. Anyway, so there is a reconciliation committee that's dealing with this review now. So what has the Trudeau government done in terms of their promises? They said there will be 3 federal paths to reconciliation. They created a new category of tables called Recognition of Indigenous Rights and Self-Determination Discussion Tables, on top of the existing modern treaties and self-government tables which exist across the country, including out here in Nova Scotia, and resolving land claims. And of course, that's the process that I guess it's Crown Indigenous Relations now, with the joint technical working group with AFN, who's been dealing with the specific claims process there, and you've been talking about that here for the last 2 days. But those are the 3 paths that the Trudeau government's identified to reconciliation. But what have they done? Last year they passed 10 principles on Indigenous relationships without consulting First Nations chiefs or the people, or even AFN, who's a partner under an MOU on shared priorities. And if you unpack those 10 principles, you'll see they're based on the Doctrine of Discovery, Constitution Act 1867, the past 30 years of jurisprudence on Section 35. It's very restrictive. They also, for example, Principle 6 says they aim to get free, prior, and informed consent, when actually the UN Declaration says states shall obtain free, prior, and informed consent. In any case, they're watering that down into 10 principles. They also announced they're dissolving or splitting the Department of Indian Affairs into 2 new departments. Again, that was without consultation with First Nations or leaders. They created 2 new ministers, 2 new deputies. We heard from Sheila that she's not sure if she's in CERNA or DISC. There are machinery government issues about which piece is going to go where. That's created a lot of uncertainty for our people, but that's tied into the framework that's coming. And they did that. They said, Prime Minister said they did that based on the recommendations of the Royal Commission on Aboriginal Peoples. But the first recommendation of the Royal Commission on Aboriginal Peoples is that the courts, given the Mikisew decision yesterday, and the government should stop relying on the Doctrine of Discovery and Terra Nullius as racist colonial doctrines. That recommendation was ignored by this government. And like I said, they've established these recognition of rights and self-determination tables. Initially, these were called exploratory tables. Initially, the government kept it secret who they were talking to in discussions and what was on the table. They've since made the list public because it's First Nations, Métis, and Inuit groups, and their agreements, a number of their agreements are also listed on their website now. And the outcomes of those tables are supposed to feed into this legislative framework that's coming. As Joe Wild, the Senior Assistant Deputy Minister for Treaties and Aboriginal Governments, told a media outlet that the exploratory tables are an arena for new interpretations of Section 35. So they're covering a wide range of issues, including treaties. So the recognition and implementation of rights framework, that was announced on Valentine's Day. The government says they want to introduce the bill in Parliament before Christmas break. Minister Bennett has said that to the media. The Prime Minister has said he wants it to be law before the next federal election in 2019, which also happens to be the 50th anniversary of the 1969 White Paper on Indian Policy, just so you know. And the Minister of Crown Relations has stated that the recognition framework will be enabling legislation and it will be opt-in. And that the Standing Committee could consider amendments to the bill in the new year. So they have a pretty tight schedule for this bill, from what they're saying. According to that September 10th document, the overview document, the structure of the legislation is going to include definitions, a preamble and purpose of the legislation, a section on obligations binding on the Crown, implementation of the framework. There will be a section on institutions, amendments to the Interpretation Act is a section, and there's reference to new policy on recognition and implementation of Indigenous rights. So the framework is a mix of law and policy. measures. The framework involves the reform of federal laws and policies involving the rights of Indigenous peoples, and it says all relations between the federal crown and Indigenous peoples, and includes treaties, pre-75 and post-75 and agreements. Now they say pre-75 and post-75, but really it should be pre-1983 and post-1983, because it was in 1983 the Constitution Act was amended to say for greater certainty land claims, agreements, or treaties within the meaning of 35(1). So that's why there's two categories of treaties, modern treaties and the original treaties. But they retroactively made the James Bay and Northern Quebec Agreement protected under that section in 1983, so that's why they're saying pre-75 and post-75. The agreement only aligns federal laws and policies with the UN Declaration. It doesn't say implementation in there. It's also based on the 10 principles for Indigenous relationships, which I think is problematic given my previous comments about those principles. And the framework will respect Canada's current constitutional framework, including the division of powers. So there's really not much room to accommodate First Nations governments in this framework. Under definitions, they're going to have key terms to guide the draft legislation, but they say they won't necessarily be included in the legislation itself. I think that's problematic because the Trudeau government's taken a lot of our terminology like nation to nation and reconciliation, even treaties and the inherent right, and put their own policy definitions to them, which have been very restrictive. So I think that should be a concern, is what are those definitions of those key terms going to be. And of course that goes for the preamble. It's going to be a set of principles that includes cooperative federalism and legal pluralism to guide the relationships. They're proposing in the discussion, in the overview document, the number of other terms to be included in there. And then the purpose of the bill is to ensure the federal government fulfills its obligations to Indigenous peoples' rights by supporting Indigenous peoples in determining their own nations and collectives, and encouraging a range of options for the federal recognition of self-determined Indigenous nations and collectives and their authority to govern themselves. So the framework is to help support. Under the obligations binding on the Crown, they're saying the legislation would be to enable choices to pursue self-determination through constitution or reconstitution of nations and collectives, to enable Canada to recognize a nation or collective as an entity that has the authority to govern itself through a government having the legal capacity of a natural person. We've talked a bit like that's a corporation, it could be like a municipal corporation. But this was brought up during the First Nations Governance Act, this idea of having governments that have the powers of a natural person or legal capacity. After recognition, the government body could then exercise core governance powers. To support the recognition process, legislation could oblige the ministers to set up other measures and approaches in collaboration with Indigenous peoples. And this recognition process, I raised it in a question with our welcome yesterday, or I guess the day before, on the Access to Information Act. I pointed out the federal government doesn't recognize Indian Act bands as self-governing bodies because they're under the Indian Act. It's only if you sign agreements, like self-governing agreements or modern treaties, that you're considered to be an Indigenous government. And this framework reinforces that as well. Their proposed structure of legislation says that Governor and Council, on recommendation of the Minister, can add recognized nations or other collectives in their governments to a schedule of the Act. So you basically have to apply to be a recognized nation or collective. And they'll take into account an ad hoc advisory committee or institution's advice on whether the group that's applying to be recognized as an Indigenous nation or collective should be recognized and added to the Act as an Indigenous nation. The list of powers and core governance jurisdictions would be set out and could be exercised after recognition. So after you have an agreement, you can recognize them. They're not recognizing you have rights before having an agreement with them under this framework. Processes to amend the list of powers can be done with the advice of a new institution. Legislation gives options to nations or collectives to leave behind the Indian Act or provisions of other federal statutes like the First Nations Land Management Act, stay until they're ready to transition out of the Indian Act or other federal statutes. Or they could substitute nation or collective to take on the legal aspects of the ban. The ban could delegate that to this new nation or collective. In terms of implementing the framework, they're talking about institutions. The legislation could expand the mandate of existing bodies or create a new institution or institutions, which could be based on co-development, shared governance. Key functions of any expanded or new institution could include an advisory role for the federal recognition of Indigenous nations and collectives, alternative dispute resolution, oversight of Indigenous rights implementation, and oversight on reconciliation and public education. The legislation could equip the minister to receive independent expert advice to support his or her role in the process for federal recognition of Indigenous nations and collectives. So you can see a key part of this legislation is to determine if you're going to be federally recognized or not. The legislation could allow the minister to strike such a committee on a case-by-case basis as Indigenous nations and collectives come forward to seek recognition. In carrying out its duties, any such committee would have to consider, and I think this goes to research units, issues like traditional Indigenous knowledge, forms of evidence, methods of study. The minister could be required to take the advice of any such committee into consideration in providing the ultimate recommendation to the Governor and Council on to whether or not to provide federal recognition of the nation or collective. The advisory role could be undertaken by the institution or any one of the institutions provided for in the legislation to fulfill alternative dispute resolution, oversight, and education functions. So a lot of this overlaps with a lot of the work that research units do, and also the existing political organizations I would submit. So under alternative dispute resolution, they're proposing that optional or non-binding alternative dispute resolution services, including required research, could also be provided by an institution to help resolve issues related to fulfillment of the Government of Canada's obligations with respect to the rights of Indigenous peoples and matters related to the federal recognition of nations and collectives, including composition and membership. So you're transitioning from Indian Act bands into these new bodies, right? In addition, nations or collectives could access the services on matters related to sharing or overlapping territory with other nations or collectives. They're also proposing that if an institution were to be created, it could be required to take into account Indigenous knowledge, legal traditions, and customary laws. Things that Arthur Walkham was talking about in her presentation yesterday. Oversight of Indigenous rights implementation would be another section. They're saying a new or existing institution could monitor and report on the fulfillment of the Government of Canada's obligations under legislation, treaties, and other agreements related to rights. So you see that's pretty sweeping. Such an institution could be required to, one, prepare an annual report detailing its observations to the Government of Canada's fulfillment of its obligations, as well as a review of its dispute resolution services and tabling the report in Parliament. Here it's just proposing amendments to the Interpretation Act to add a non-derogation clause. And also, they could also repeal existing non-derogation clauses to ensure a more harmonized federal approach to the interpretation of legislation. So here's the interesting one, a new policy on recognition and implementation of Indigenous rights. So they're saying they're shifting away from imposing pre-crafted federal mandates and limited opportunities for agreements to evolve with co-developed paths forward. Canada's negotiations, they say, need to catch up on their approaches. So they want to replace the comprehensive land claims and inherent right policies with a policy on recognition and implementation of Indigenous rights. And they would entrench co-development as a basic standard for federal engagement with Indigenous peoples to advance the implementation of their rights. The policy could be built on the principles of citizen-centered design with Indigenous peoples at the heart of the process. It could formalize policy innovations that are already creating significant progress at negotiating tables, which is those recognition tables, such as co-development of all negotiating mandates and new approaches to certainty. which as we know is a euphemism for extinguishment. The policy on the recognition and implementation of Indigenous rights could specifically seek to provide mechanisms to uphold and implement obligations set out in the legislation. It could be co-developed with Indigenous peoples, and they can build on a range of policies and mechanisms, that will be required to support the legislation. And that includes supporting the capacity of Indigenous organizations and governments to fully realize their potential. So this is an excerpt from a letter that the Indigenous lawyers sent to Prime Minister about this whole process on August 21st. And you can see they're saying to the Prime Minister, basically about this overview document that I've been going through. The basic materials we've been provided appear to misstate foundational legal and constitutional concepts, specifically views expressed to us by senior officials about the meaning of co-development, recognition, implementation, Indigenous laws, Indigenous jurisdiction, treaties, Aboriginal title, engagement, consultation, free prior informed consent, self-determination, self-government, among other topics, are not legally correct. That's quite a mouthful. They say the initiative, this national engagement process that this process has been going through, fails to appreciate or understand that legal rights have already been recognized by the courts in Canada in a multitude of cases where inherent Aboriginal treaty rights have been consistently affirmed for Aboriginal peoples and Treaty First Nations peoples. They go on to say, we urge you to take a look at the current path and reset. They're also saying the Attorney General, who's mandated on this initiative, should be engaged to provide legal advice and direction for the Crown as well. And absent this, they're saying our concern is that the current initiative will only give rise to more litigation, as it does not appear to be in accordance with the law of Canada. So, Budget 2018, there's a reconciliation chapter you should have a look at, but that sets out spending in these areas of reconstituting nations and other aspects that the framework is referring to. And also, as I mentioned, the government response to the Standing Committee gives some indication on the federal intent on the land claims policies and the linkage to the framework. There's much we don't know because the government hasn't been really transparent on this new policy that they're talking about to replace the existing ones. And even that document laying out the structure of the legislation is pretty sparse. But it does raise questions like what role, if any, do the existing research units have if this framework goes forward, because they do talk about research being necessary to support groups seeking federal recognition and also dealing with their treaties and other issues. Part of the institutions they set up too is dispute resolution. So I'm not sure whether the specific claims tribunal may or may not fit into that. Some First Nations and their organizations are seeking to co-develop the legislation. In any case, it seems the federal government's decided that reconciliation and nation to nation means that they're transitioning from the status quo into a new relationship, which clearly affects land claims policies and processes. And with that, I'll turn it over to Cook B. Wilson.
Thank you, Quiet Tap. Chief Judy Wilson, I'm the Union BC Indian Chiefs Executive Member, and I'm also Chief of the Neskonlith Indian Reserve within the Nisquam Nation, which is one of the largest nations in the interior of British Columbia. And we had 32 ancestral nations, and the 2 epidemics we were reduced to 17 today. But I wanted to first of all acknowledge our BC Specific Claims Working Group, and they can just give a wave or stand up if they're here. My co-chair, Chief Dalton Silver, and I'm the other chair. And then Councillor Sherry McIntyre, is she here? And then Councillor Kevin Whitney. And we have some technicians that work with us. Jody Woods, there she is. Emily Milliken, there we go. And Robin Baba.
Not here.
And Joanna Reed.
Not here.
And also I just want to acknowledge our UBC staffer, Angie Bainter, who's working at all levels with us. I just wanted to thank Russ for his presentation, because I felt it was really important for researchers and directors and any of the institutes you work for and the lawyers across Canada to understand the implication and the impact of the recognition implementation and rights framework, because it's going to impact all aspects, and it's not being clear exactly how it's going to do that, especially what Russ just pointed out with the independent tribunal, the independent call for specific claims process, and then the tribunal part. We've been calling for an independent process for quite some time, and we recognize the deficiencies and the flaws in the comprehensive claims policy and the specific claims policy. But again, the steps we're doing under the recognition and rights implementation, is that going to improve it. You already seen in parts of it that there's not a real true recognition of our Indigenous governments. It's still based on the divisions of the federal and the provincial powers. And even though it's saying good words about self-determination and about recognition, it's not giving that true space which is called for under the Constitution 35, 1982 for our space as Indigenous governments within the division of powers. So I wanted to point that out because it's really going to be, I feel, problematic as we're moving forward in resolving our outstanding land claims across Canada, whether they, and they're the ones that divided it into comprehensive and specific claims, but there's a lot outstanding and it's still a lot backlogged. So you can see from the chronological history of the land claim policies in Canada, how Canada is shifting and moving, and we can see how they're still ignoring our call for the independent claims process. We were told it was going to be put into the cabinet and dealt with this fall, but we still have no clear indication that is even going to happen, even though Minister Joe Wild at our Union of BC Indian Chiefs meeting earlier this year had stated that he was going to do this, but apparently it hasn't happened. And I want to also underscore the continued conflict of Canada's interest in these processes. And what we've seen, what Russ pointed out, it's going to continue, and more blatantly. And I also wanted to point out, with the doctrine of discovery, we've been calling for that to be repudiated. The World Church Organization, they repudiated it many years ago now, but we can't seem to get that clear enough. We can't continue on these colonial notions of doctrine of discovery and terra nullius. And it seems to be still involved in the work that Canada is doing. There has to be a clear repudiation of it in the work that they're doing. And also the UN declaration must be fully implemented, not domesticated under Canada's laws. And because when they say they're just going to align it, that's really what they're saying. We're going to align it to our Canadian law. The United Nations Declaration is international law. It needs to be fully implemented. They can't parcel it out or cherry pick it. It needs to be fully implemented. The other issue is I think is really important, is the inherent title and rights of the nations. We cannot be told there's only these three paths. You have to sign a self-governed agreement or a comprehensive self-governed agreement to be recognized. When we call for recognition, that's not what we're saying. We're saying we need to be recognized with our sovereignty, are recognized as nations for our inherent title and rights. Not, again, put under a frame or a comprehensive agreement of Canada saying now we can be recognized as persons, now we can be recognized as Indigenous nations. So that's really problematic, and I hope you can wrap your head around what that really means for the nations you're working with. Because in our nation, we have our 1910 Sir Laurier Memorial that was really clear. We have our laws, you have your laws. We will share 50-50, but it was based on our sovereignty and our title. We weren't expecting that our title would be given up, even if it was in a treaty. It was recognizing our nations, our inherent title and rights as a nation, not as someone under the province, under the municipality, or under Canada. And I think that's the other thing we really pressed on the issue was we were not federal, notions of federal municipalities. Joe Wild repeated several times, no, that's not what we're meaning. But what do they really mean when we have to sign a self-government agreement to be recognized as a person or recognized as a nation? That's not how we were calling recognition of our Indigenous nations. And the other one is, we had Minister Bennett and Joe Wild running around saying they were moving away from extinguishment. This wouldn't be based on extinguishment. But it's still, they haven't been clear, even on the material they released in September, on how they're removing extinguishment. And also, how are they removing the debts from the treaty bans? I was at one meeting, they said, no, we'll have to work it in a fair way to determine what the debt is to each other. And I was thinking, well, that's not removing debt, and that's not removing extinguishment. Russ pointed out in part of the slide what it meant on the extinguishment part. And then plus there's two sides to that extinguishment. When the treaty bands are selecting through their land selection processes, they're removing land from the nation that's held collectively. When they're doing that, it's still a form of extinguishment. Maybe not that they're doing towards the treaty ban, but towards the non-treaty bans, it's extinguishment because they're removing the lands that are collectively held to our nation. So there's other issues in regarding the proposed process that we have to really be monitoring. We have to be clear. We have to be dialoguing it more. That's why we felt it was pretty important to be here today to talk to you about what this really means. It's not just a political discussion. It's not just a discussion at the AFN level. It's not just discussion for the political leaders. It needs to be discussed here with the researchers as well, because you need to be advising your leadership. You need to be advising the different tables of what these implications are. And I know a lot of the researchers here and the directors, a lot of you are very dedicated and hardworking for your nations. And you kind of need, if you haven't already, to get really underneath this and really what it means. And if this legislation is being proposed for next year, we have to look at, how we're dealing with it. Ideally, as many of the nations that I attended the meeting with on September 11th and 12th in Gatineau, Quebec, by the Assembly of First Nations on Policy, many of the nations called for halting this policy. In BC, they talked about, co-developing it, but if you really looked at what our drafting instructions meant, it was quite a departure from what they were presenting, the government, and what the co-drafting that Louise Mandel called for was almost like a whole another set of legislation, because it had to be grounded on the principles that the government isn't working from. So there was a real, and I don't understand how it came out of the AFN, because we had very clear resolutions. I think they were led by Ontario chiefs calling for the halt or stopping the recognition and rights implementation framework. So that was really clear. And I don't know how this whole work about salvaging the legislation came about, but I don't think it's can be salvaged. You see, our top legal experts in the country come together and say it has to be a total reset. And must add a hard reset. It wasn't calling for a soft reset. The legal experts pointed out many flaws already in the approach, let alone the document that was released in September 7th, Russ?
Yeah,
September 10th, sorry, I get my...
Publicly.
The public one was released then. But anyway, I wanted to share those points with you, and hopefully you can digest them. Russ and I will be around for most of the day. Would invite conversations on that. Russ is posting some of this on his what's the campaign site called, Russ? Truth Campaign, and there'll be some more information there as well. But we're hoping to be able to go to other conferences and have other dialogues at other sessions, because as Indigenous people in Canada with the outstanding Indigenous land claims, this should be the focal point of any of our meetings that we come to. We need to be talking about this, not in the media and just, conversational. We need to have this move to the forefront to be dealing with up front and squarely tell Canada, they're not listening to us. They haven't heard a word we said, about the historical treaties nor the inherent town right treaties, and even from the modern treaty tables, they're still not getting that message. We have to get out there and make sure they're hearing our message. Cook's Chairman, thank you.
Whitehouse Hope, Inches Quees Nassas Pasquas, Inches Caleb. I'd like to recognize the Mi'kmaq Nation for hosting this meeting. My name is Dan Wilson. I'm a council member with the Okanagan Indian Band, member of the Sealed Nation. All of this stuff, I've been involved in politics off and on since 1987, and I've been out of politics for 12 years, from 2003 to 2015. And it seems like we're like a broken record. A lot of this stuff we've been talking about since 1987, and it doesn't seem like we need much progress. It seems like we're losing ground. And to me, being raised on my grandmother and elders in my community, it seems like we're forgetting who we are. I mentioned it on the first day about the Royal Proclamation of 1763 and why we still refer to us as the Okanagan Indian Band, because we're referred to as Indian allies in the proclamation. And that's the Royal Proclamation is embedded in the Canadian Constitution, which is supposed to be the supreme law of the land. And we're supposed to get the Crown is supposed to get our public consent before we can be dispossessed of our land. And it's all in there in the Constitution. And I've been told by elders that the law is there. It just needs to be implemented. And so to me, the sooner, it seems like the further we get away from the Royal Proclamation, the further we're getting away from the Crown's obligation in respect to our title and rights. There's one thing that I was taught when growing up, and it has to do with our tax exemption. And I went to law school and received a law degree from UBC in 1997. And I can remember a professor by the name of Joss Bloom at UBC. And we were in a conflict of laws class. And he looked me square in the eye and he says, the reason for your tax exemption is based on international law. Under international law, one sovereign nation cannot unilaterally impose a tax on another sovereign nation, because to do so is a form of slavery. Slavery is illegal under international law. So that's the reason for your tax exemption. So I've always remembered that, and I've learned that from my elders even before I went to law school. And you take a look at these modern treaties and agreements and stuff, it's all geared towards getting rid of our tax exemption, getting rid of our sovereignty. So that's just an example of us, in my opinion, getting away from who we are, forgetting who we are. We're allies of the Crown under their own law, under our law. And the War of 1812 with Tecumseh and all that, there would be no Canada if it wasn't for the Crown's Indian allies. So I think that's the basis that we need to proceed on, and to always remember that, remember who we are. So I guess that's more of a comment. I've been involved in the specific claims process for a number of years. We settled a number, as I mentioned before. Justice Slade was our lawyer in '84. We settled the Kalmalka Lake claim back then. We settled one in 2002 where we added 2,200 acres, or in the process of adding 2,200 acres to our reserve. And it's just delayed. But, you know, I can go on and on about our experiences, but I guess that's the comment I want to make and leave with everybody today, is to remember who we are. We're allies of the Crown. We're not subjects. Yeah, we're under the Indian Act and all of that, but to me, we're under duress. We never agreed to that. It was because of the epidemics, and that's another point that's always missed. You know, there was a good book that came out in 2012 by Tom Swanky, who got his information right from the BC archives. And, you know, if you read that book, there's, you know, pretty high probability that those epidemics were purposely spread. And we leave it to that, you know, for people to do their own research on that. But that's the reason why we're in this position today. You know, just to end up here, I remember an elder, Tommy Gregory, a great ward from my community. He talked about Governor Douglas coming to our community after the epidemics come through in 1860, and basically dictating to us, saying that, you know, if you live peacefully on the reserve as part of their peace order good government agenda, you know, we will manage your traditional territory for you. And out of the proceeds, he said, never forget the word proceeds. You know, we're not there hat in hand, it's our territory, our unsurrendered territory. But because of the epidemics, they were able to dictate to us, and they said, we'll manage your traditional territory. You know, the proceeds we'll provide you with the following services: health care, which is the medicine chest, the vaccines in order to survive, housing, education, water, RCMP protection, tax exemption. There's kind of forget all the promises that were made, but anyways, those promises are all alive and well today in regards to the Crown's fiduciary duty towards us. It's not out of the goodness of their heart that they provide us with those services. You know, and those services were basically meant to keep us on the reserve, to keep us from practicing our traditional life ways out in our traditional territories. So, but anyways, you know, that wasn't in line with the Royal Proclamation of 1763. So, in closing, I think we need to get back to that and remember who we are and start from that basis.
Thank you very much. I hate to do this to this panel because I think it's a conversation that needs to continue, and they've certainly indicated that there's forums and avenues to do that today and ongoing.